time. Let's break this mother down. With Shizzy, Wiz, Nut.
Man, oh man, what do we have that the judge just came up with today? He has had just about enough of Bubbles' filings. Now, tonight I'll be doing a stream at about 10 o'clock going over Bubbles' latest filing. And I'll also be going over the judge's latest order. And I've got a new letter for you folks. I hope that you're ready for a mess. I figured I would hit this really quick, but we're going to discuss this just a little bit more tonight and show you just how angry this judge is in this case. He's done playing with this, and he has made it very clear, as we said here earlier this week, the judge is done playing around with this silliness. Well, let's dig into it. United States District Court of the Northern District of Florida, Gainesville Division. And you notice the judge likes to put that up there. His order is, defendants have filed 4 motions. Defendants. And each one of those motions has been for attorney's fees under USC 1927. These documents, 104, 105, 114, 116, the motions all seek the same relief and should have been filed as one motion, not 4 separate motions. We brought this up the other night when we were talking about this, that he's filed 4 motions in no time at all. Thus, those 4 motions are stricken. The court is tired of both attorneys in this case clogging the docket with unnecessary, duplicative, and meritless filings. Now, I'll say that Shockett wouldn't have to have multiple filings if he wasn't responding to Bruce. So I think the judge is clearly showing that he's had about enough of Bubbles' garbage. The quantity of judicial resources that have been consumed by this case is ridiculous. The simple 1 plaintiff, 2 defendant defamation case has 117 docket entries, and discovery has not even been completed yet. The court hereby notifies counsel that at the hearing previously scheduled for April 3rd, 2025, the court will also be addressing whether both attorneys should be sanctioned for their continual abuse of the judicial process and unprofessional litigation. So let's see what this little subnote is that he has here, the notation. And he says, he's explaining here to both attorneys, this is what he is going to be looking at come April 4th. The following filings will be addressed at the hearing, all of which appear to be possible violations of Federal Civil Procedure 11 because they were frivolous and or presented for improper purposes, which would be 1, defendant's motion for reconsideration, 2, defendant's motion for reconsideration, which are basically the same thing, just with 2 different people. And then it was, of course, the plaintiff's motion to dismiss the counterclaim and the plaintiff's motion to dismiss the counterclaim. Well, on both of those. Let's get back into what the judge has to say after that subnote. He has several federal civil rules, procedures stating that the district court may issue sanctions after ordering an attorney to show cause. And he continues on with another one. A court may impose sanctions for litigation, misconduct under its inherent power. And it also continues to cite another one, recognizing the court's inherent power to effectively manage its affairs by punishing and deterring abuses of the judicial process. The unprofessionalism of both lawyers in this case surpasses anything the undersigned has seen before. When counsel for both parties show up for the hearing on April 3rd, 2025, they must bring their checkbooks. Indeed, the court probably should have issued sanctions earlier in the case, but the court does not like to issue sanctions, believing that lawyers, as officers of the court, will and almost always do behave after being warned. Thus, the court has tried to cajole compliance with the rules in other ways and has been patient with counsel. That obviously has not worked. Instead, the attorneys in this case have taken advantage of the court's patience and abused the judicial process no more. Defendants, now he's going to give a rule here for just the defendants. They may refile a single motion for attorney's fees under 28 U.S.C. 1927. And he continues to say, for the plaintiff may respond to that motion. Plaintiff may also respond as previously ordered by Doc 113. But other than those filings, neither party may submit any additional filings barring an emergency situation. What does he say about an emergency situation? If the parties claim something is emergency and the court finds it is not, then the offending lawyer will be sanctioned. In this case, until after the hearing on April 3rd of 2025. He is saying that the judge is saying he's had enough. We talked about this much earlier this week in our nice little letters that we like to write to Bubbles, which I have a new one for him tonight that should be quite interesting. And I'm going to also give a breakdown of that filing he filed under 117. And I've got a few things to point out under his last filing, Bubbles' last filing, and I'm going to make it pretty clear, along with a nice, enjoyable letter. And then I will also have a letter that I'm going to add on to this particular order for Bubbles. I hope that you guys come by tonight at 10 o'clock. It should be quite a joy. Should be quite a bit of fun. We're hopefully I will have the wonderful Yamaha biker on with me tonight. And if not, well, I can just say you might want to stay tuned because it's going to get really interesting. The judge has just about had enough, and he's going to make it very clear come April 4th, come next Thursday. The judge is going to lay down the law, and he's telling both attorneys to bring their checkbook. We'll see. We'll see exactly how all of this goes. But until then, you guys have a wonderful night, afternoon, day, wherever you might be, and I'll see you tonight at 10. Peace.
It is about time. Let's break this mother down. With Shizzy, Whiz, Nut.